All right. Hello, everyone. Good evening. Thank you so much for joining us for the Physician Immigration Update Summer 2026 with Elissa Taub of Siskind Susser. I wanted to take a few minutes just to give everybody time to log on. I'll start by introducing myself. I'm Lainey Bargan. I am the Events Communications Specialist here at Practice Match. If you've ever attended an in-person career fair or visited us at a conference, you may have seen me already. Practice Match has a list of free career resource aids to help you along your career journey, such as webinars just like this, CV Builder interview, as well as career fairs, scholarship opportunities, and more. So make sure to check out our website for more information about that. I do want to remind everyone that this webinar is being recorded and all microphones have been muted and cameras turned off for the duration of the event. Please put all questions in the Q&A chat box and we will answer them live. And we will also send you a link to the recording by the end of this week. So it looks like some attendees have already logged on. If you are ready, Elissa, you can go ahead and take it away.
Awesome. Thanks so much, Lainey. It's great to be here with you all this evening. I know folks may trickle in as we get started, and that is totally fine. I'm just going to start off with a few housekeeping things, and I'll introduce myself. And so that way, as folks kind of filter in, they won't miss, too much substance at the beginning. So I'm Elissa Taub. I'm a partner in the immigration law firm Siskind Susser. I head up the firm's healthcare immigration practice, and I am also the co-author of the Physician Immigration Handbook. I have been exclusively practicing in the area of immigration law for 20 years. Most of that time, I've also been focused on physician and healthcare immigration. I've been practicing law, though, for about 26 years. So I was doing something else for the first few years of my practice and then switched into doing immigration partway through. Most of what I do is work with physicians. And so I'm happy to talk with you tonight about some physician immigration updates. And some of this that we'll talk about tonight is more general immigration updates, but we'll specifically talk about how things apply for doctors. A couple of housekeeping measures as we get started. Please keep in mind that this is not a confidential setting. So I am happy to answer questions in the chat or the Q&A box. But this is not a confidential setting. So please do not share personally identifiable information or really private information in those spaces. The information that I'm providing tonight is just that. It is all being provided for informational purposes. I am not intending to become everybody's lawyer who is watching this webinar, and the information I'm providing is not intended to be legal advice. So please keep that in mind as well. But with that, I think we can get started. Let's see. Whoops. There we go. So this is a little bit of our agenda for tonight and the things that I intend to cover in the webinar. We're going to talk a little bit about green cards at the beginning. We'll talk about the $100,000 H-1B fee, which still, even all these months after it first came on the scene, is there's still confusion and still information I get asked on a regular basis. So we're going to cover some of that. We're going to cover some updates in the travel ban and benefits pause area. We'll talk about risks of travel, things to think about, some stuff going on in J1 waiver world since we're about to embark and really are getting started now on the 2027 J1 waiver season. And then we're going to cover some other miscellaneous updates at the end. So let's get started. I think, for folks who are on this, who are watching this webinar, who are still in training, not yet out in the attending world, maybe aren't even thinking about a green card process because you're like, I just need to get a J1 waiver job. I do want to cover a few things about green cards just at the top here, because there are some important developments going on, and there may be folks who are also watching who, for whom this is actually really important information. The first thing to know in green card world is that as of May 22nd, the government announced that it had issued all of the EB2 green cards for Indian nationals for this fiscal year. That means that no more green cards can issue in that particular category until at least October 1st. This came as a big shock. Normally, we don't get these announcements until much later in the fiscal year, maybe July, August, September. This year it happened in May. The EB3 category, as of right now, is still available for Indian nationals, and I am seeing some of those cases get approved. But for now, there are no EB2 cases that can be approved for Indian nationals. If you look at the visa bulletin and you look at that category, you're going to see a U on there, and U means unavailable. That means that you can't file, you can't get anything issued for the time being. So that was a really big development, because in the months leading up to that, we had seen a lot of forward progress in the issuance of green cards for Indians, and in the movement of those of the priority dates. So it came as a big shock. We'll talk in a little bit about why this all might be going on. And actually, well, I guess we'll talk about it now. So one of the things I'm very concerned about, though, for people who aren't from India and aren't from China, but who are from the rest of the world, is that we may see some widespread retrogression in August and September. What does retrogression mean? It means that we might see the development of some backlogs in the EB2 and further backlogs in the EB3 category for other folks. And part of that is that since November, December timeframe, USCIS was not approving any green cards for people from the 39 travel ban countries. And at the same time, the US State Department wasn't issuing any green cards to those folks abroad. Last month, and we'll talk about this a little bit more in a few slides, the USCIS lifted the benefits pause. And so I think they're looking forward, and they're looking forward and backward, and they're saying, well, we have all of these green card applications pending for people from those 39 countries. We now need to quell demand, because we have to go back and potentially approve some of those cases, and we need the capacity to do that. So I think we're going to see the ability to file cases, get pulled back, and we may not see as many green card approvals starting in August and then into September. We'll see how that pans out. Get the August visa bulletin at some point this week. I had checked right before this. I haven't seen it come out yet, but literally any moment. So, my predictions may not be correct, but that's kind of what I'm seeing in the background. And the State Department has warned us for the last couple months that this might happen. So it wouldn't be outside the realm of possibility. So that's some of what's going on with the availability or unavailability of green cards right now. We also had this memo that came out back in back in May that really caused a lot of furor. People were really confused and worried because USCIS issued this policy memo that said that people who want to seek green cards can't do so from inside the United States and would need to travel abroad to seek a green card. And so I was getting a lot of questions from folks about, hey, do I have to leave the country right now? Like, what do I do? And the answer was no. You don't have to leave right now, just because someday you might want to seek a green card. And in fact, we are seeing adjustment of status applications for green cards for people inside the US get approved every day. The government has not stopped issuing those approvals. And the implementation of this memo has been relatively inconsistent. I wouldn't say that USCIS has completely pulled it back or that they're not paying attention to it, but it is not being implemented as stringently as they initially signaled that it would. So if this is something that you've been thinking about, something you heard about, late May, that, oh, I'm not going to be able to get a green card from inside the US anymore, I might have to worry about that, I would calm down about it and not really, I wouldn't lose any sleep over it. I think this is one of those things that will need to be considered on a individual by individual basis. But for most folks, this is not going to cause ultimate, problems in seeking a green card, at least for now. All right, so that's our green card headaches. And I should, before we move forward, I also want to say a couple of things about these policies, because this adjustment of status memo is, to me, indicative of a pattern that the government seems to be showing periodically with these policies. They come out with a policy that's very inflammatory. The way it's written is really kind of scary. We immigration lawyers read the policy. We're like, oh my gosh, this is going to be terrible. You know, this is what it says. We advise our clients appropriately. The government says, yeah, this is going to be a really harsh policy. And then people get in the ear of the administration, people who with knowledge, businesses who have workers who are affected, things like that. And all of a sudden you see a softening of the policy. Maybe not officially, but you kind of see unofficially the policy get walked back and not implemented as stringently as we initially were led to believe. So that's kind of what happened here. And we see that happen in other situations as well. That doesn't mean we shouldn't take these policy memos and announce policies seriously, because some of them are being implemented harshly. But it does mean that we need to, um, kind of wait sometimes to see how things play out. And as an attorney, what happens in my practice often is that these things come out and my email box sometimes gets flooded within 1 or 2 hours of the policy being announced, but we don't really get more information for a few days. And so I don't always have that information or the, snap analysis to tell folks right away. And so sometimes we need to be a little patient in the face of these things so that we all can read, talk with colleagues, strategize, kind of figure out what the ultimate message is that the government is trying to send. And actually, something like that, also happened with the $100,000 fee, right? That proclamation was signed by the president on September 19th, 2025. And that was a Friday. And he signed it we got the text at like 6:30, 7 o'clock at night. I was out at dinner with friends and was like, hey, you guys, I gotta go. Like, I need to read this thing. And it was really scary. We had people, on H-1Bs all over the world who were like, can I even get back to the US, right? There was so much confusion. And the government, officials were making all kinds of inconsistent statements. And it took the government a month to give us guidance on the $100,000 fee. So for that month, we were just guessing about how things were really going to work. So that's a great example. And they did roll it back a little bit, right? The $100,000 H-1B fee, as it turns out, is triggered only when somebody needs to process an H-1B outside the United States in order to come back to the US to start work. So that means the person is starting this process from abroad and the H-1B is filed for that person when they're not here. Or it means that for some reason, the person is not able to extend, change, or amend their status inside the US and is going to need to take a trip abroad and then return to the United States to make that H-1B effective. In those types of cases, the $100,000 fee has to be paid before the H-1B is filed or in response to a request for evidence if USCIS makes that determination along the way. I know of employers who have paid the fee, but I will tell you it is not a widespread thing. And it really is done by employers on a case-by-case basis. They're going to do a cost-benefit analysis. They're going to determine if that role, if the physician, if the situation warrants paying the fee. Know that doctors are not exempt from the fee. That is a huge myth. It's a rumor that's been going around since the early days of this thing. And people still say to me, but this doesn't apply to doctors. And I'm like, oh, heck yeah, it does. But it doesn't apply that are handled entirely from within the United States. So if you're a J1 doctor and you're going to be getting a J1 waiver, at the end of your J1 waiver process, when that waiver is pretty much approved, you've got your medical license and everything, your employer is going to petition to change your immigration status from J1 to H1B because you can't be on a J1 for an attending position. You've got to switch away from that. And we're going to switch you to the H. The law requires that. Those H-1Bs, as long as they're processed entirely, they're filed while you're here in the US, it's approved while you're here in the US, and your start date, everything is approved with you here in the United States, the $100,000 fee shouldn't apply in those cases. So for J1 doctors, this is something generally you won't have to worry about unless for some reason there's some problem and you've got to depart the US before starting work. Most immigration lawyers, myself included, are trying to make sure that doesn't happen. And we are giving pretty clear advice on, when not to travel, and that you need to be here through the whole, through that H-1B time is very critical. One thing to know, and you may see some talk about this online in chat rooms or things like that, is that the $100,000 fee proclamation expires on September 21st, 2026. When the fee was announced, it was only announced as being effective for a year. Right now, the government is still expecting payment of the fee for start dates beyond that. We expect the government to announce that it's going to be extended, but personally, I do not expect them to do that until it's the eve of that expiration date. They have not been making these announcements of things like this well far in advance, so expect that it'll be extended. Expect that that might not be announced until like the eve of September 21st. The other thing that's currently causing confusion on this is the fact that on June 8th, a federal district court in Massachusetts vacated the $100,000 fee proclamation. They said the president did not have the authority to implement this fee because they said it was an illegal tax that he could not do unilaterally, could not do by himself. However, the government appealed the decision on June 18th, and the district court judge had told the government that if they filed their appeal by that date, that he would stay his decision, stay his order pending appeal. And what that means is that the order striking down the fee now is on hold. And so the result of that is the fee is still in effect as if nothing has changed. And it took, again, this is another situation where time was important. It took 10 days between June 8th and June 18th for all of that to happen, between the court's order being issued and the government appealing. So there were 10 days where this thing was really struck down. But by the time, but then by the time the 18th, and really it wasn't even fully till the 18th. I think the initial stay was put into effect around the 11th or 12th. And then the judge said, file your appeal by the 18th or I'm going to lift my stay. So they filed their appeal on the 18th. So, that's another situation where we're trying to keep clients updated about what was going on, but things were changing kind of, rapidly, and there was a lot of confusion about what was going on. So right now, $100,000 fee is still in effect. There are 3 lawsuits that are out there, including this one. 2 are now on appeal, this one and one pending in Washington, D.C. There's another case that's pending in Northern California. Arguments were held in that case in February, but the judge still has not issued a ruling, which at this point is pretty shocking. So we're still waiting to hear from that judge. So that's what's going on with the $100,000 fee. So let's talk about travel bans and the benefits pause. I think this is super important and something where there has been a lot of change recently, except not on the travel bans. So there are there's a travel ban, there are full and partial travel bans that were announced last year, one in January, and then it was re-upped in December with an effective date in January this year, sorry, June and January is when they've gone into effect. So we had a ban initially, and then more countries were added as of January 1st of this year. The full ban is like you can't get a visa to come to the United States. So if you are abroad, there are no visas that you can get, just as a baseline. The partial ban is you can't get a green card from outside the US, and you can't get an FM or J or there are 39 countries affected by these bans. I'm not going to sit and read you a list. It's very easy to find that information online. Folks who are dual citizens, where you're a citizen of a banned and a non-banned country, are not subject to this. This has not changed. The government, says that they would be willing to entertain applications for exemptions in the national interest for this ban. They're very hard to get, not saying it's impossible or that it hasn't happened, but they're not issuing them freely, these exceptions. The other ban or pause is this immigrant visa ban, or immigrant visa pause, as the government calls it. And this is also still in effect. This went into effect in January of this year. It applies to people from 75 countries, but it only applies to immigrant visas, which are green cards that are applied for outside the United States. And the basis of this ban or pause is that the government believes that everybody from these countries stands a high risk of becoming a public charge in the United States, meaning they won't earn enough money here to support themselves and will need to fall on the government for assistance. That's what that immigrant visa pause is based on. That also is still in effect. That does not affect most of my physician clients because most of my physician clients seek green cards from inside the US. And it really has a disproportionate impact on people seeking green cards from abroad based on family relationships, marriage to a US citizen, spouses of permanent residents, folks like that. So that's where we really see the disproportionate effect of the immigrant visa pause. Those two Department of State, and these are largely, administered by the Department of State, and those are still in effect. What's changed? What's changed is that USCIS benefits pause. This went into effect in the November-December 2025 timeframe, and it said that for anybody from the 39 countries, whether you were just born there or whether you still hold citizenship there, it doesn't matter. USCIS would take your application and not do anything on it. They would not approve it. They would not issue an RFE. They would not deny it. They would just let you file and then not do anything. And for a lot of reasons, that was a big problem. And it was becoming a growing problem because there are time limits sometimes to how long people can stay or work while cases are pending. And the longer that this pause was in effect, the larger this USCIS inventory of all of those pending cases was going to be growing. And so you could imagine how many cases are just like sitting on the shelf, not being looked at. And at some point, we figured they would lift the ban or lift the pause. And all of a sudden, the government has to go back and review all of those cases. And that is exactly what is happening now. Also in June, early June, a few days before the $100,000 fee decision, a federal district court in Rhode Island struck down the benefits pause in its entirety, said USCIS, this is ridiculous. You can't do that. In the days after that decision, USCIS said nothing about it. And if you have been following along, you know that USCIS does not usually stay quiet in the wake of a court decision. They will post something on their website criticizing it or fighting back or things like that. And they did not do that here. They did nothing. So the court a few days later came out and said, hey, USCIS, maybe you didn't understand me. You've got to implement my order now. You have got to lift this ban. And they gave them a deadline. And they met that deadline. And they issued a memo that says that they rescinded the 3 policy memos that implemented the benefits pause. And in the weeks, it's been about a month since all of that happened. Very, very slowly, we are seeing some applications and petitions get approved. We are seeing them get worked on. But if I think about this from the standpoint of a USCIS officer, these folks already have the cases on their docket that they have to do within a normal time frame. They're premium processed, they're, whatever. And now they've got to go back and pull these cases off the shelf that have just been sitting there for, 8, 9 months. So I think those cases are all going to get looked at, but slowly. I have one J1 waiver for an affected physician that got to USCIS around February that was approved. I have an I-140 for an affected physician that was filed in January that we got a very easy request for evidence and responded to that yesterday. So hopefully, we're going to start to see these cases get worked on, a little bit, maybe slowly, but it looks like there's some movement on those cases, which is really exciting. I have a few other doctors who are affected by the pause for whom we also have J1 waivers pending at USCIS, and we're now filing their H1Bs with premium processing on a rolling basis in an attempt to get USCIS to approve the waiver and the H1B so the doctors can start work. I have got several of them pending now that we're trying to do that with. So hopefully that will start to bear fruit and we can get these cases across the finish line. It's very promising. I'm really encouraged by by this, with the caveat that, anything can happen. So I believe the government may have appealed this. We don't know what's going to happen moving forward, but for the time being, the benefits pause has been lifted, cases are being worked on, and that's all really, really good news. It's probably the best news I've had in a year and a half. So on immigration stuff. So we'll hope that things continue to move forward. All right, let's see. So talking about the travel bans, obviously for folks that are affected by those travel bans and by the visa suspension, for folks from those 39 countries, travel is risky. If you're not from one of the 39 countries and you're from one of those 75 countries, you can, theoretically, you could travel without a problem. It does not apply to H's and J's and, things like that, right? That immigrant visa pause for the 75 countries is only about green cards. So I get that question a lot. And so I just want to be very clear about that. That said, there are risks involved in travel right now. And I get asked about it just about every day. And it pains me to advise folks either not to travel or to be very cautious about travel or to really pull back on non-essential travel. But the risks are real and there are things that come up in my practice regularly. So I want to spend a little bit of time, kind of going over all of this and providing this information so that folks are aware of things. So this is, starting last summer, the State Department said, look, everybody who applies for a visa needs to do so in their home country, and they need to do so with an in-person interview. Even children, even old people need an interview. There's no more Dropbox processing of visas. Everybody's got to go for an interview. That has caused, a significant uptick in demand. In India, we still are seeing shortages of appointments and very lengthy wait times to get an appointment for an interview. We've also seen problems in the Middle East as, hostilities have started and then stopped and then started and then stopped. And, U.S. embassies have had to open and close repeatedly to ensure the safety of their staff and for the folks coming for visas. So that there's been some chaos there. When this policy was first implemented, most consular posts were like, sorry, if you're a third country national, we can't help you. If you're not from here or not resident here, like we can't help you. Over the last few months, I don't know how many months, but there have been some posts that have loosened up. The policy has, I don't want to say the policy's gone away. It absolutely has not gone away. You still need to process in your home country. But if you're from a place like one of the Middle East posts that has been affected by the war with Iran, then you may be able to convince another post where you have the ability to be for a little while that they can accommodate you elsewhere. The State Department also on their website at travel.state.gov, there's a link to something called the newsroom, and you can look up U.S. visa news there. And it lists, there's a link there that talks about all of this, and it actually will give you like specific alternate posts for certain places where the U.S. does not have a diplomatic presence and can't accommodate visa applications. They give you the other post where you're supposed to go. Sometimes it's not all that easy because the alternate country where they tell you to process is like, sorry, we're not giving you a visa to come here. So, you sometimes have to be a little creative there. But there is, if you have a good reason, what I suggest is if you do want to process as a third country national somewhere because there's some real strong reason that you need to do so in that space, that you reach out to that consular post in advance to ask them whether they would be willing to accommodate you. If they say yes, then they may direct you when to make the appointment so that you can actually get access to third country national appointments, because otherwise those appointments may not be available. If you just go in randomly and look, for third country national appointments, for the most part, you're not going to see them available at most consular posts. It's not the way it was previously when they were like, you can process anywhere. That is definitely not the policy right now. One thing that we're seeing off and on and is very troubling is a resurgence of, not even a resurgence, but a surge or an uptick. Let's call it an uptick in visa revocations. In the past, we really would see this only, if somebody was in the United States legally and got a DUI, the State Department would do what's called prudentially revoke their visa, so that the next time you have to travel abroad, you need to go for visa stamping, and they could assess whether you were trustworthy and all that stuff. What we're seeing now is an uptick in situations where somebody departs the United States, and as soon as they step a toe outside the country, they get an email telling them that their visa was revoked. And so you have no way to know that that's going to happen in advance. And now you're outside the United States, and you may only have a trip of 4 or 5 days planned, and now you've got to go for visa stamping, and you've got to figure out why was the visa revoked, and the government's not going to tell you. Most of the time, there's some law enforcement basis for the revocation, right? You were arrested previously, convicted of some kind of crime, even if it was many years ago, and they're like, yeah, we just need to see this person again. If something like that should happen to you, an immigration lawyer. I would not tell you to like go about that on your own and try to figure all of that out and navigate that by yourself. Those types of cases can be really challenging. And you want somebody who can prep you for the interview, really discuss with you frankly and in detail about what caused that, what might have caused that visa revocation, and how to potentially overcome it if it's possible. A lawyer's going to know about trends, what they're seeing in other cases and things like that. So definitely something, if you're a person that in the past has had some run-ins with the law, maybe you've even had what's called a 212(d)(3) waiver in the past, where you got a waiver of inadmissibility based on a criminal past, and you've been getting your visas based on that for some number of years. Your ability to continue getting those waivers may be impacted by changes in attitude at the government. And so it's important to consult with an attorney if you're in that position to make sure that you're well aware of risks of travel. One thing that also has come up over the last year is this idea of social media vetting. At this point, it applies to a slew of folks who are applying for visas, including J's and H-1Bs and H-4s, basically J1, J2, H-1B, H-4, Fs, Ms, like there's a whole list of them. It's important to understand that, one of the things that really bothers me about this policy is that it does apply to dependents. It applies to children who have to go for visa stamping. And the policy requires any visa applicant to make their social media profiles public from the time they schedule the appointment until they go for the interview, so that a consular officer can review their social media for anything that the US government deems challenging, objectionable, contrary to American values. Like there's a whole list of things. And personally, this bothers me because, children are particularly at risk when their social media profiles are public, and that profile may need to be public for some period of time abroad and go for visa stamping is, what are we going to do with our social media? The consular officer, if there's some problem that the consular officer notices with this,
It looks like we're having a little bit of technical difficulties. I am reaching out to Elissa just to make sure she's able to get back in. So if you just give us a few moments.
So sorry that I dropped off. My home internet somehow decided to take a break. So um, let's dive back in. Apologies for that interruption. I'm glad y'all are still here. Um, so anyhow, we were talking about social media vetting for visa applications, and if your visa is refused on this basis, or if you end up in administrative processing on this basis, the consular officer likely isn't going to tell you. You're just going to get a 221G letter, or they're going to tell you you're refused under Section 214B and leave you to figure it out. The 221G letter is, administrative processing. That means that there's some delay in them issuing your visa, and they want to do a little extra checking. It could mean an extra background check. It could mean a lot of things. Administrative processing is a very broad category. But if your visa is refused under something called 214B, they're not going to tell you why. And it can be challenging to challenge those kinds of visa refusals. So, it's hard for me to advise you on in this setting to, really talk about the things that could cause you problems with social media. I would not tell you to, delete all your social media and call it a day because the government will know that too. So, being careful about things that you say on social media, unfortunately, for now, is something to consider so that it doesn't cause you problems with potential visa processing in the future. And of course, there may be new policies that come out, and we'll have to navigate those as they come. Let's switch gears a little bit, talk about J1 waivers for a few minutes, and then we'll wrap up with some other stuff. For right now, for those of you who are here in this presentation, who are in J1 status, who are going to be seeking waivers, I will tell you just generally, there has been no change. There are no changes to the J1 waiver process. The process works exactly like it always has. The waiver, if you're applying based on working in an underserved area, requires you to sign a 3-year contract to work full-time in an underserved area. You're going to apply either through a Conrad 30 program or through a federal agency. They're going to review the waiver. They might, if they recommend it, they send it on to the State Department. The State Department reviews it. They send it on to the Immigration Service. The Immigration Service approves the waiver. Your employer petitions for you to change to H-1B status. That overall that overall procedure that J-1 waivers go through, unchanged. Most J-1 waiver programs, the rules, the way that we apply, all of that unchanged. Where I am seeing issues arise with J-1 waivers right now is with a few of the federal agencies that are empowered to grant unlimited numbers of waivers. And most of that is in the form of delay. And where we're seeing those delays are first with the Appalachian Regional Commission, or ARC. They have suspended their program between May 1st and October 2nd. It says October 1st, that's a weekend. But anyway, between May 1st and October, they basically said that folks can continue filing applications like normal. All the applications that reach them will be filed, but they are not going to continue looking at cases until early October. And then they're going to review the applications in the order in which they were received. So if you're looking at, ARC jobs, in that area, come October, the program should reopen. We do not know right now if they're making any changes to their rules or what's going on with it. But just know that now the program is not really operating. So if you have a case that's pending there, don't expect to hear anything back for a while. The SCRC, the Southeast Crescent Regional Commission, is the next one down on that list, and we are seeing increasing delays with that program. Back in June, they were recommending waivers that were filed in March. I have a good number of waivers that were filed there in April. We've not gotten a recommendation on any of them yet. The program has significantly slowed. I do not have a reliable reason to tell you why. It reminds me a little bit about what happened in HHS earlier in the year. So personally, I wonder whether the folks that were causing difficulties at the HHS program then turned their attention to SCRC. Maybe that's why ARC is suspended for 5 months, because they're undergoing a review by minders at the federal government level who, want to meddle in these things. I don't know that for sure. That's my personal speculation. But we're getting really concerned about the SCRC, and we can't even get a response from them. We get very intermittent responses to inquiries that we send. And this is, a real big mounting problem. So certainly something that we are watching very closely and kind of taking action on behind the scenes. The HHS program was having the same issue earlier in the year, between October and maybe like March-ish. They didn't recommend any waivers. So again, that was what, November, December, January, February, about 5 months. So all of these pauses, it seems like, are taking about 5 months. No idea why. And then there was mounting pressure. We went to Congress, we went to the press, and we, meaning a lot of immigration lawyers, and got some attention focused on this program, and they resumed processing. And now all of my HHS waivers that I filed this year are well through the program. A lot of them are fully approved by USCIS. So hopefully the same thing will happen with the SCRC, where the program will resume quickly, and we're just kind of waiting to see what happens with that. Otherwise, the way the process works is pretty much the same. The Conrad 30 programs, all of them vary. Even all of these programs, they all have different rules and regulations. If you're sitting here tonight and you've signed a contract and your employer's like, hey, we're filing with the SCRC, and you're like, oh my God, that lawyer just said, like, that's a problem. My assumption is that after these reviews happen for the coming fiscal year, so for your 2027 waivers, that these problems are going to be a thing of the past. I think that there's some political oversight going on in these agencies, and once that is complete, the things will move forward more normally for the coming fiscal year. So if you've signed a contract, please do not go back to your employer and your employer's lawyer and tell them that I told you that this is a problem. It is not. We are taking in, signed contracts from folks that we plan to file in all of these agencies in the coming year. So, we expect things to kind of open up and be more normal going forward. All right. Some other notable stuff. What's on the horizon? What else is going on? One thing to know is that back in December, the Immigration Service announced a new policy regarding pictures. There are some types of applications that we file that used to require us to send in little passport photos with the application. In December, the government announced a policy where they said, we don't really like those photos that you send us. We don't really think they're reliable. We would rather take the photos ourselves. And so for the types of applications that are listed here, some attorneys are still sending in the photos, but USCIS largely isn't using them. Instead, they're sending everybody for a biometrics appointment to go get a photo taken that they take. Most of these types of cases were having biometrics already or did at some point in the past, but the one place that this has become a real issue is with H-4 EADs. H-4 EAD applications, we used to send in the photo, and if I filed the H-1B, the H-4 application for the spouse, and then that EAD application for the spouse, and if I filed them all together, and I filed the H-1B with premium processing, we'd pretty much get all three of those applications approved within days of each other. What's happening now is I'm getting the H-1B and the H-4 approved quickly, but the EAD has to go for biometrics, and then it's pending. And we're seeing the processing times on these work cards lengthen considerably. Seems like the government may be open to expediting if somebody requests an expedite, but it's really important to know if you're, a doctor who's in H-1B status already and your spouse is in H-4 and they have an EAD, or you're in J status and your spouse is J2 status and you're planning on, filing for an H-4 EAD at some point, it is really, really important to know that your experience now is not going to be the same as it was previously, and that we don't exactly know how long it's going to take to get these H4 EADs approved. The other challenge is that the government largely did away with those automatic extensions for pending EAD renewals. So if you have an H4 EAD or your spouse does, and your employer is about to, extend your H1B and you're going to file an extension of the H4 and the H4 EAD, that H4 EAD may be pending longer than the expiration date, and your spouse's ability to continue working based on that EAD does not lengthen, does not automatically extend. It ends with the EAD expiration, which is the way things kind of were in the olden days, and they fixed it because people had to people had to stop working all the time because EADs weren't being extended in a timely manner by the government. So these are all things to kind of note when it comes to EADs, but specifically H4 EADs. This is a growing issue. I'm starting to get more and more like nervous emails from clients about this, and we're trying to keep our finger on the pulse of what's actually going on with them. But it's something that is a developing issue. So it's hard to know all the parameters with it. Some things that are coming out, we know that at any time now, the government is going to publish a final rule doing away with duration of status entries for F, M, J, and I visa folks. If you're in your final year of training on a J, this may not have a lot of impact on you, but for other folks, when this rule comes out, if it does not exempt physicians, it is going to drastically change everything about your J1 status. You may find that over time, if you're going to be doing residency plus fellowship, that you may have to apply to extend your J1 status with USCIS, which is something you don't have to do right now, because when you're admitted to the United States, your I-94 is stamped DS for duration of status, which means that you can come in for as long as it takes to finish your program, and the issuance of your DS 2019s every year, that's what extends your stay, right? Like, there's a whole process in place for that. This new rule may change that. We have not seen final text yet. There was a proposed rule. There were a lot of comments made about how awful this idea is and that it shouldn't happen. But the government was really committed to implementing it. We know that the rule has passed all the final layers of review at the government level. We kind of thought it was going to come out last month, and it still hasn't. So we're not really sure what's going on or when it's coming, but at some point this rule may be coming out in final form. And at that point, we'll be able to give more detailed information about how that might affect doctors in training. It's not in effect yet. So for right now, nothing to do, nothing you need to prepare for. There's nothing really you can do or prepare for, because we don't really know what the rule is going to say. And of course, the administration is, putting out new policies all the time. We've talked about it a few times during this webinar that, it can be difficult to know exactly how to interpret these things. And sometimes we are going to need time to read them and understand, and may not be able to tell you immediately within an hour of a new policy coming out how it's going to affect you. But, we all are reading everything, trying to keep up with all the different policies and information that are being announced all the time. And of course, if there's something really late breaking, may hop on a webinar or some other venue to do some last minute updates. This is my contact information. In addition to myself, there are a few other lawyers in our firm who primarily work with doctors. My law partner, Adam Cohen, associate Megan Moody. The three of us, regularly consult with doctors who have questions about physician immigration issues. You could go on our website at visalaw.com, and, there's a button to schedule a consultation, and you can kind of look and see who's available. But the three of us, myself, Adam, and Megan, are the three that really focus in on working with doctors. So if you are, interested in scheduling something like that, we'd be more than happy to chat with you. And I know Practice Match also makes available online a version of our Physician Immigration Handbook. And if you ever see me at a Practice Match career fair, you can buy and get a free hard copy of it. I will be at a couple of them later in the year, I think in Chicago and New York. I will be at those in November. So if you're there, please come by and say hi and tell me you saw me on a webinar. And with that, I'm going to stop sharing my screen. I think there are questions in the Q&A, and I apologize. I usually am able to get to these while I'm speaking, but due to my technical situation, I wasn't able to. So let's tackle some of these questions real quick. I don't think there are a ton of them, but I should be able to get through them. So how long is perm approval roughly taking from being filed to being eligible to file I-140? That's a great question. Right now, they're taking a little over a year. If you would have asked me this a year ago, I would have told you 18 months. The Department of Labor has gotten those processing times down to about a year. So last week, I got a bunch of perms approved that were filed on June 26, 2025. So it's just a little more than a year. That's really good news. The Department of Labor has told us that likely will continue. Can't tell you they're going to get any faster, but that's what they're looking like right now. Next question. If all applicants have to go home to their home country for an in-person interview, does that trigger the H-1B fee? No. If your H-1B is approved while you're in the United States and it's approved like a change of status or an extension of stay, and you get a little I-94 at the bottom of that approval notice, you are able to travel fee-free. The $100,000 fee does not apply to you in that case. The only time, like if the $100,000 fee was going to apply, it would have to be paid to USCIS in order to get that H-1B approved. So if your H-1B has been approved and you travel abroad, the $100,000 won't apply. And stated a little differently, USCIS is the only government agency that collects that fee. So the State Department doesn't collect it at visa processing. Customs and Border Protection does not collect it at the border. It's only collected by USCIS. Let's see. No, so that's a great question. So this gentleman says that he's currently waiting for USCIS to approve his HHS waiver. H-1B petition is pending. And is there anything they can do to expedite? And honestly, no, that's exactly what I would do to try to expedite the waiver. I'd file the H-1B with premium processing and ask USCIS to approve both at the same time. Sometimes they will issue a request for evidence on the H and say, hey, you need to give us proof that your J-1 waiver was approved. And you're like, you have it. So in those cases, I email USCIS at the Premium Processing Service, and I'm like, hey guys, can you coordinate to approve this waiver? And in most cases, they write me back and say, done. And then we respond to the RFE and everything gets approved. So that is something that does happen, but I think the situation you're in right now sounds like exactly where you need to be. Okay, and then Stephanie has a couple of questions here. Would doing board extension of DS 2019 interfere while waiting on the J1 waiver approval? No. The J1 waiver and the board exam extensions are completely separate. And typically ECFMG will not give you a hard time getting the extension even with a waiver approval. And USCIS will not hold up your waiver approval for the board exam extension. So they are totally separate from each other. So that shouldn't be a problem. And in terms of processing times for J1 waivers of non-banned countries at USCIS, right now I'm seeing them get approved within a month. Yeah, within a month. They've been really fast. There are, let's see. So interestingly, sometimes on a J1 waiver, the USCIS case status will say that your case has been transferred to another office, and you won't receive a note or a notice or any explanation of where it is. What I think that means is that an officer has it and they're working on it. It could be that they're doing some extra background check or something like that, but we have been seeing them about 4 weeks. In a normal year, I would say usually about 6 to 8 weeks. So if you're at about 6 weeks right now, I wouldn't say that that's abnormal or outside of processing times. You just might be on the longer end of normal right now. I would probably give it another, maybe another week or so before I'd, be concerned. If it's pending that long, one of the things I would do, as I mentioned before, is I would file my client's H-1B and see if that pushes things through. I had a case last year for a physician where the doctor's J-1 waiver was taking forever. I mean, it was like 6 months at USCIS, and we could not get them to give us any information. We kept filing service requests and calling and couldn't get any information. So finally, I was like, you know what? Let's just file as H and see if that'll push things through. And sure enough, we got a biometrics notice, and he went, and then we got an RFE that was about like some traffic incident from like 4 years ago that they wanted to know about. And so we responded to that, provided all the information that they wanted, and they approved it. So sometimes filing the H-1B can be a good strategic way to get some attention on the waiver and figure out exactly what's going on that's causing a holdup. Let's see. No, okay. So if you, the question is, once this person's H-1B is approved by USCIS related to that HHS J-1 waiver, would they have to go to the Indian consulate to get a new visa stamp? And the answer is no. When you change status from J-1 to H-1B inside the US, you get a new I-797 approval notice, and at the bottom of that will be a new I-94 that shows that your new status is H-1B, and it'll have your validity dates, which should be 3 years, sometimes a year, depends on the situation. But it'll have the validity dates for that new H-1B status. That approval notice with the I-94 at the bottom is your work authorization. That becomes the proof that you are now in H-1B status. You do not have to take a special trip abroad to go for visa stamping. You don't need an EAD card. You don't need anything else except for that original I-797 approval notice. If you have travel planned later and you want to go abroad, then you will need to go for H-1B visa stamping in order to come back to the United States in H-1B status. But initially, before you start work, HHS J-1 waiver, switch to H-1B status, and then you can start work. You don't have to make any special trip, which is nice. I sometimes have clients that want to take trips over the summer, and sometimes I'm like, go for it. And sometimes I'm like, oh no, like, please, I don't want you to miss your start date. Please hang out for a little while longer. But well, thank you all for your wonderful questions and for your attention this evening. Apologies again for the little weird technical glitch. I have to go check and see what's going on with my Wi-Fi here. But it's been lovely to be with you. And Lainey, I think we can wrap things up.
Awesome. Thank you everyone for joining us tonight. Like I said, you will be getting this recording to your email by the end of the week, and it will also be published to our website if you want to watch back and see any information you might have missed. Other than that, make sure to check out Practice Match, our website, to see all of our other resources and to also sign up for that immigration handbook that we talked about. Thank you so much and have a great rest of your night.